Hey guys and gals, this is the BarExamandChill podcast. I'm your host TJ, and today I'm going to go through the July 2019 UBE civil procedure question. This is MEE Question 6 on that exam if you want to follow along. And just before we start, I guess, I just wanted to say it's July 14th. I know we're getting close. Hopefully everybody's feeling relaxed. I know all you're doing is studying, basically. So your life's not even that good. I've been there. But anyways, I don't have too much time, I guess, after the actual bar exam. And nobody's going to be studying for the bar anyway. But until this end of July 2026 exam, I'm available on Patreon. That's all I'll say. You're never going to find cheaper prices to talk to a lawyer ever again. That's you're all going to find out in practice how valuable. I mean, I'm being reasonable. I just want to help people, I guess. But, you know, it's nice to get compensated if you're trying to do a good job here. So if you need help on the bar, just get at me. Let's get into the hypo here. I'll just jump right into it here. Trident Healthcare, Inc., incorporated in State X, owns and operates hospitals and clinics in State X, Y, and Z. Medical information for all of Trident's current and former patients is stored on computer equipment housed at Trident's corporate headquarters in State X. Last December, unknown persons hacked into Trident's computer system and obtained the personal medical information of at least 30,000 Trident patients, including 5,000 patients living in State X, 10,000 patients living in State Y, and 15,000 patients living in State Z. However, there is no evidence that the thieves had used any of this medical information. The State X Privacy Protection Act imposes an absolute duty on healthcare providers, including companies like Trident, to keep patient medical information private. The legislature concluded that the invasion of privacy resulting from data breaches causes significant harm to the individuals involved. Thus, the law allows any person whose private medical information is obtained by an unauthorized third party in any manner to recover actual damages from the healthcare provider. Further, because such damages are sometimes difficult to quantify, the state law provides that an individual is entitled to a minimum statutory nominal damages award of $500 to compensate for this invasion of privacy. This state law is not preempted by any federal law. A man who is a citizen of State X and whose medical records were stored in the Trident computers has brought a class action in the Federal District Court of State X against Trident on behalf of himself and all the persons whose healthcare information was taken during the hacking of Trident's computer system. The man is represented by counsel with extensive experience in class actions of this type. The complaint is limited to claims arising out of the hacking of medical information. It seeks no actual damages, but does seek statutory damages on behalf of all members of the class pursuant to State X statute. The complaint alleges the facts detailed above and alleges that the court has jurisdiction based on diversity pursuant to 28 U.S.C. Section 1332. The complaint also alleges that most, if not all, of Trident's patients are U.S. citizens who are domiciled in the states where they receive their health care. State X legislatively adopted civil practice rules provide that if any statute or law of this state allows for an award of statutory or nominal damages, recovery of such damages may be sought in an individual action but not in a class action. Trident has moved to dismiss the man's class action brought in federal district court, arguing that 1. The court lacks subject matter jurisdiction over the state law claims raised by the class action. 2. The action fails to allege a claim upon which relief can be granted because of the state law barring class actions to recover statutory damages. And 3. The man does not have standing to bring a statutory damages claim in federal court. With respect to each of these arguments, how should the court rule? Explain. Nice. So let's get into this. Anytime you're on the bar exam again, you're trying to flip through your Rolodex, issue spot. Hopefully you have like all your law statements that you need to know in your head, kind of that you can flip through. But you want to just open and lay the groundwork of the law. Sometimes just like really obvious, simple things like background law, like in con law, literally like you kind of start with that preformed paragraph that's like the United States follows federalism. We have a federal government and state, just a full paragraph basically describing like the ground rules of the law. Sometimes it's good to have that kind of stuff, basically just notched down so you can go on exam time. You're just starting to spit it out, right? Anytime you're in a federal civil procedure question, you're probably going to have maybe a short discussion of like traditional diversity. Here you've got a class action, but I would still probably just start with that, even though it's like not technically like 100% maybe relevant. It's still law, I guess, that you're putting down like, hey, first you go through your traditional diversity jurisdiction and then we'll go into CAFA. So let's look here. Our first issue is, the argument here is subject matter jurisdiction under CAFA. Our issue is, does the federal district court have subject matter jurisdiction over the plaintiff's state law class action under traditional diversity jurisdiction or the Class Action Fairness Act? Okay, our rule for traditional diversity, this is one you're going to have down cold probably already. It requires complete diversity of citizenship between all named plaintiffs and all defendants, and the amount in controversy for the named plaintiff's individual claim must exceed $75,000, exclusive of interest and costs. And there's some nuance to the diversity jurisdiction that you want to know for the MBE, right? Like in the actual forum state, if the defendant is from that state, they can't, the forum state defendant rule says they can't remove it. Also, you want to remember under the traditional diversity jurisdiction, if a defendant removes in an individual case, the defendant has to have the consent of all of the other defendants, right? So the removal is a defense. The plaintiff chooses the forum, you sue in that forum. It's, usually the plaintiff wants to be in state court. They sue there. The defendant has the option to remove unless you have this like forum state rule. If it's a home state defendant, they can't remove it, right? But you want to remember all those little nuances there in traditional diversity jurisdiction. So we've got, they've got to be diverse and then over 75,000. Then let's get into CAFA. Our rules for CAFA is CAFA, CAFA is the Class Action Fairness Act. You just there's like traditional removal and then there's CAFA removal. So you'll want to know for class actions they actually have in the statutes. It's in like the U.S. Code. They have like their own requirements for removal. So let's go through those. For CAFA removal, it grants federal district courts original jurisdiction over class actions arising under state law if 1. The proposed class contains at least 100 members. 2. There is minimal diversity. This is different than the regular. Every plaintiff has to be diverse from every defendant or whatever, right? In a traditional individual action. But here you've got minimal diversity, which we're going to define. So there is minimal diversity, which means at least one plaintiff class member is a citizen of a different state than any defendant. So you have a much more relaxed requirement here for diversity. It's minimal diversity. Again, at least one plaintiff class member is a citizen of a different state than any defendant. And our third requirement for CAFA removal, the aggregated amount in controversy must exceed $5 million, exclusive of interest and costs. You want to take note of that word aggregated, right? Because in a class action, basically you're taking all of these little tiny damages that you're alleging and you're adding them up and saying that the violation of the law impacted, maybe 10,000 people, 50,000 people, whatever it is. Here we've got like, 50,000 people or so. So again, for CAFA, let's just run through those quickly. 1, got to have 100 people. 2, minimal diversity. 3, aggregate amount has to be above $5 million. So there's your requirements for CAFA. You've got this home state controversy exception for CAFA removal. A federal court must decline jurisdiction under CAFA if more than 2/3 of the members of the proposed plaintiff class and the primary defendants are citizens of the forum state. So, if you're suing and you sue a class action, they're going to want to remove it to federal court. The federal courts are typically more favorable to the defendants, and they have stricter deadlines for like class certification, and the standards, of the law basically in federal courts tends to be more favorable to defendants. So they like to remove it, right? once they remove it, the plaintiff is going to seek any way to try and remand that case back down to state court. Plaintiff does not want to be in federal court, right? So one way that they can try to argue that it should be remanded, if there's a removal, the plaintiff might try and rely on this home state controversy exception, where a federal court has to decline if over, again, 2/3 of the members of the proposed plaintiff class and the primary defendants are citizens of the forum state. So if you're suing in Utah, or you're suing in California, or you're suing in Colorado, let's just say you're suing in California. If you're suing in California and 2/3 of your class members are in California, the forum state, and one of the principal, the primary defendants that you're suing, they are also citizens of California, then you have this home state controversy exception, and a federal court must decline jurisdiction, which means it will get remanded and the state will proceed in state court. That's what we're arguing, right? As lawyers, your venue is very important that you select. The plaintiff is going to want to choose the most favorable venue. Sometimes they analyze whether a law is better, right? Like some jurisdictions might not allow punitive damages, and there might be a cap on punitive damages. So the plaintiff seeks their forum, and the defendant also wants to litigate a claim in the forum that's most favorable to them. That's where all this litigation comes. And you're going to see this in practice, right? There's going to be fights about where you actually litigate the claim. That's what civil procedure is ultimately about. Let's get into our analysis on the facts here. We've got our law. You go through, hey, here's traditional diversity. Here's CAFA removal. Let's get into our analysis. So for traditional diversity, the named plaintiff is a citizen of state X in our hypo. The defendant, Trident Healthcare, is incorporated in state X, making it a citizen of state X. So because both the named plaintiff and the defendant are citizens of the same state, complete diversity is lacking. Additionally, the named plaintiff seeks only $500 in statutory damages on his individual claim, failing to meet the $75,000 threshold. Thus, traditional diversity jurisdiction does not exist, and you can't remove on those grounds. Then we go into CAFA jurisdiction. Class size. The class consists of at least 30,000 patients, right? You take the number of people that are alleged to have been affected in the complaint. You say, hey, this is our class of people. Here you've got these patients that have like this informational, there's some kind of privacy invasion of their medical data in the hypo. So yes, right, it's basically alleged to have impacted at least 30,000 people. This easily satisfies our class size of 100. So our first requirement of CAFA jurisdiction, we've got 100 people. Yes, it's at least 30,000. Minimal diversity. Here, Trident is a citizen of state X. The class includes 10,000 patients living in state Y, 15,000 patients living in state Z. Because these individuals are domiciled in those states and receive care there, they are citizens of state Y and Z, right? This is given to us in the facts. Since numerous class members are citizens of states different from the defendant, minimal diversity is met here, right? I mean, you just have to have any person in your class is basically different. So here, yeah, you've got people that are citizens of state Y and Z. It's given to us, so there's minimal diversity. Our amount in controversy under CAFA, the claims of the individual class members are aggregated, right? So you got these 30,000 people. They're seeking statutory damages in the amount of $500. So you just take that, hey, if the statute was violated for all of these 30,000 people, times it by $500, this is why you start to see class actions are very valuable and lucrative, because you take all these claims and aggregate them up and you get these giant dollar amounts. So with 30,000 class members, each seeking $500 in statutory damages, the total amount in controversy is 30,000 multiplied by 500. That gets you to 15 million. That is comfortably exceeding the $5 million threshold. So we've got our three requirements met, right? Class size, is it over 100? Yes, we've got at least 30,000. Minimal diversity. Yes, some of our patients here are citizens of state Y and Z, and the defendant is state X. So yes, we've got minimal diversity. Amount in controversy, you take this 30,000 people, you times it, each one of them by $500 statutory damages that they're seeking. You get your 15 million. Is that over 5 million? Yes. So you go through your analysis there. You might throw in here Trident, the plaintiffs might seek this home state exception. Trident is a citizen of state X. For the mandatory home state exclusion to apply, more than 2/3 of the 30,000 class members would need to be citizens of state X. However, only 5,000 class members are citizens of state X here, right? So therefore, the exception does not apply. And you can say, yes, the exception doesn't apply. It can probably be removed here. Relaxed removal procedures under CAFA. So let's get into the differences between removal under, this is going to be heavily tested in the MBE portion as well, but the nuances here for removal. There's some differences between traditional removal and CAFA removal. So what are they? I think I kind of touched on this, but there's a unanimity requirement under traditional removal. What does that mean? Well, if the defendant removes, the other defendants have to consent, right? But under CAFA, so I guess I'll just start with the standard removal rules. So under standard removal rules, all served defendants must consent to removal. Under CAFA, any single defendant may remove the action to federal court without the consent of their co-defendants. So let's talk about what that means, right? Well, if a plaintiff sues like three corporate defendants, and you'll find when you get into the law, when you're suing corporate entities, a lot of times, it's not always 100% clear which entity. Some of them control payroll. There's holding companies. You have to kind of like be judicious about who you're actually suing, right? But, oftentimes a plaintiff will name multiple defendants. If they worked at, Target, but there was like it could be that there was like a local company. You might sue the actual individual, like your manager, plus you might sue the corporate entity, plus you might sue like an HR representative or whatever, depending on the facts of the case and what's going on. If you've got multiple defendants in a traditional case, if the defendant, let's say the corporate defendant wants to remove to federal court, he's got to have consent of his other named defendants, right? They all have to be like, yes, we're fine with this removal. Under CAFA, that's not the case. Any corporate defendant, again, you got to kind of remember these CAFA rules are meant to be a little bit business friendly. So they're trying to help the corporate defendant remove the case to federal court. Again, it's a little bit more favorable on the law. So you've got this no unanimity required. Under CAFA, the defendant doesn't have to have consent. They can just remove it. There's no forum state defendant bar. That's key as well. We talked about that, right? If you're suing a defendant, they're a state X corporation in state X, there's a forum defendant rule where they can't remove it. But in CAFA, that doesn't exist. So in typical diversity cases, a defendant cannot remove a case if they are a citizen of the state where the lawsuit was filed. But under CAFA, that waives the limitation. A local defendant can still remove the case to federal court. That's a key distinction. Also, let's talk about traditional removal rules, right? The defendant, what's his deadline? He's got 30 days. It's not 30 days from the filing of the complaint unless it's immediately apparent on the face of the complaint that it should be removed, right? If it's immediately apparent. It's 30 days from the time it's basically like discoverable that it could be removed, which is, an argument. If the defendant misses their deadline, they might want to try and look at like discovery responses or whatever and try and argue like, hey, we didn't know that this was removable within the first 30 days. There's in CAFA, there's no 1 year limit. Under traditional rules, you have 30 days to remove it, right? From the time it becomes like apparent that it's removable. Okay, so that's your deadline to try and remove. If you miss that, you're no good. But under traditional rules, you have an absolute 1 year limitation. So if you discover that the case was removable like 4 years into litigating, it doesn't matter, right? It's not like the 30-day deadline starts at that time that you discover it. But under CAFA jurisdiction, you don't have that 1 year limitation. So it's 30 days from any time it becomes like, you discover that it's removable under CAFA. And that's no 1 year limitation. So there's the difference there. Hopefully that's clear. Our conclusion here is going to be that the court should deny Trident's motion to dismiss for lack of subject matter jurisdiction because all the statutory prerequisites for CAFA jurisdiction are fully satisfied. It met our 3 prongs there. Nice. Argument 2, we've got the Erie Doctrine here. And we're dealing with the state law class action bar. So our issue here is, does a state rule of civil procedure prohibiting class actions for statutory damages apply in a federal diversity action, or does federal rules of civil procedure 23 control? This is Law School 101. Under the Erie Doctrine, federal courts sitting in diversity apply state substantive law and federal procedural law. This is a big thing, right? When you're litigating in federal court, they're going to apply the actual substantive law of the state that it's like embracing. but they're gonna apply federal procedural law. So here we've got a state that's saying if you bring a class action, you cannot seek. If you bring a claim under this law that's being broken for statutory damages, you cannot bring it as a class action. So does that law apply now that it's, in federal court? Let's talk about it. To determine whether a federal rule of civil procedure conflicts with state law, courts apply this framework. It's established in this case, Shady Grove. They look at they want to determine if the federal rule is sufficiently broad to answer the question in dispute, i.e., whether it directly conflicts with the state law, and 2, if it conflicts, the federal rule governs if it is valid exercise of authority under the Rules Enabling Act, meaning it regulates procedure and does not abridge, enlarge, or modify any substantive right. So you're looking the case. They want to look at for these laws, is it substantive or is it procedural? That's kind of your step number 1. If it's procedural, the federal rules of procedure are going to govern. So here we've got an FRCP, which is FRCP 23. It governs class actions. It's in the Federal Rules of Civil Procedure. That should give us a hint. FRCP 23 governs whether a class action may be maintained in federal court, providing a categorical framework that applies to all civil actions where its procedural requirements are met. And we'll talk about the procedural requirements for a class action. Let's analyze it on the facts here. So State X's civil practice rules explicitly state that statutory damages may be sought in individual actions, but not in class actions. This directly conflicts with FRCP 23, right, which permits any class action to proceed in federal court as long as the rule's procedural requirements are met. And that's numerosity, commonality, typicality, adequacy, and maintainability. But I mean, really, actually, we're going to kind of go through this, there's a little acronym that you can use to remember the elements for class certification. CANT, C-A-N-T, CANT, right? You have your commonality, your adequacy, C-A, numerosity, N-T, typicality. So CANT is kind of how you want to try and remember those. If I don't know if this is tested so much on the bar. I have seen it though. It doesn't come up super frequently, but that's an easy way to remember it. So under the Shady Grove precedent, FRCP 23 is a valid procedural rule because it merely controls the aggregation and joinder of existing claims. It does not alter the underlying substantive right to the $500 statutory remedy provided by State X law. The state law limitation targets the form of the lawsuit, which is a procedural mechanism, right? They think of the class action as a procedural mechanism. Kind of interesting. Rather than altering the substantive element of the claim. So because the federal rule is valid and addresses the exact same issue as the state rule, the federal rule must displace the state rule. You're going to have FRCP 23 governs, and you're just going to have to proceed through the procedures of certifying a class action in federal court, which doesn't have this, state law bar on seeking statutory damages. So here, even though it seems like it could be arguably substantive, we see that FRCP 23 has a procedural mechanism for how a class action proceeds in federal court. So we're going to defer to that under the Erie Doctrine. And our conclusion is going to be the court should deny Trident's motion to dismiss on the ground because FRCP 23 governs the availability of class actions, rendering the state law procedural bar inapplicable. Nice. Let's get into our argument 3. A little bit con law here. We've got Article 3 standing for statutory privacy violations. Our issue is going to be, does a plaintiff have Article 3 standing to sue for statutory damages in federal court following a data breach when the stolen information has not yet been misused and no actual financial damages are claimed? So our rule for Article 3 standing, nice and easy. These should be repeatable in your head. We're getting close to the bar. Hopefully you've got them. 1, 2, 3, right? Injury in fact, a causal connection between the injury and the challenged conduct, right, traceable to the acts of the defendant. 3, redressability. Can the court do anything about it? Okay, so for our Article 3 standing, hopefully we've got our 3 elements down in our head. You're going to go through them on the test, right? You're just going to write them out. For Article 3 standing, we need injury in fact, a causal connection between the injury and the challenged conduct, traceable to the acts of the defendant, and redressability. Nice. If you've litigated in this sphere, they talk about a concrete injury. So there's this case called Spokio and TransUnion. This is key here. They hold that a statutory violation alone does not automatically create a concrete injury for Article 3 purposes. However, intangible harms can be deemed concrete if they bear a close relationship to a harm traditionally recognized as providing a basis for a lawsuit in American history or common law, such as harm arising from the invasion of privacy, intrusion upon seclusion, or public disclosure of private facts. Now, that is kind of in the weeds. If you know that, you're going to get a stellar A+++ answer. I don't think you need to have that in your mind for the bar. Just try and remember injury in fact, causal connection, redressability. But it's good to keep in mind that's the actual law. All right, let's go to our analysis here for the actual application to our facts given. Trident argues that the plaintiff lacks standing because the hackers have not yet used the information, right? That's given to us in the facts. There's no actual harm from the data breach, resulting in no actual pecuniary harm or identity theft. However, the injury alleged by the plaintiff is the unauthorized exposure and acquisition of sensitive medical information itself. That's given to us in the facts. The common law has long recognized that the unauthorized intrusion into private affairs and the dissemination of private medical data, especially, right, protected under HIPAA, constitutes a concrete actionable injury. There is a tort for invasion of privacy, right? So state X's legislature explicitly codified this intangible harm, identifying the invasion of privacy resulting from data breaches as a significant injury and providing a $500 statutory remedy to compensate for it. Okay, so they're recognizing that there's a harm here. Because the plaintiff's highly private medical data was successfully targeted, compromised, and obtained by unauthorized third parties, the injury is not a mere hypothetical risk of future harm. This is the harm that they actually suffered. That's how they're going to argue here. The invasion of privacy has already occurred, right? So the plaintiff has suffered a concrete particularized injury. In fact, that is directly traceable to Trident's alleged security failure and is fully redressable by the statutory damages sought. You have an interesting, it's just kind of interesting to note in these litigation postures what people are arguing, right? Here, you know, they're going to remove it, and then the plaintiff is actually going to argue that they lack standing to try and get the case back down into state court, which is just, it's kind of interesting to note. Okay, so our conclusion, the court should deny Trident's motion to dismiss for lack of standing because the unauthorized acquisition of private medical data constitutes a concrete injury. All right, there's the hypo that we've dealt with. I kind of wanted to just do a little bit, we've gone through a lot of the mechanisms that you have to know for the bar for class actions, and we've you know, compared those to the traditional rules of removal so that you have both. The traditional rules of removal are very, very frequently tested. So having all those nuances like the forum defendant rule and so on and under your belt, you're going to really want to know all the intricacies there. Let's just talk about class actions generally and how they're tested on the bar. This does come up. I think this was tested on my MBE section. Specifically, there are 3 types of class actions. They like to test the nuances here. So I just want to go through that so you have an understanding. Again, right, it's a procedural mechanism. What happens is you sue a class action. Typically, it's going to be removed to federal court. They're going to set a deadline for class certification in which the plaintiff has to, you know, prove to the judge that all of these requirements for certifying a class action are met. What are those? It's CANT, C-A-N-T, right? That's how we're going to remember them. Commonality, adequacy, numerosity, and typicality. Commonality, there must be a question of law or fact common to the class. It's just saying the same thing happened to everybody, right? Adequacy, the representative parties and their class counsel must fairly and adequately protect the interests of the class. So you have to have both the class representative that's seeking to represent all these class members be adequate, right? If they've got a felony for theft or something, they'll look into that. The class representative also has to be found adequate. So you can't, you know, this is actually kind of interesting. If you're a lawyer and you want to sue a class action, you have to have like, they want to look at your experience. So they're going to attest to whether the actual attorney can adequately represent, has the experience for being appointed class counsel. Numerosity, it's got to be so numerous that the class must be so numerous that joinder of all members is impractical. So you don't want to have all these individual like 50 lawsuits, right? You just join them all in a class action. That's the numerosity requirement. Here in federal court, there's no actual like number. So although CAFA jurisdiction says you have to have over 100, there's no like actual number for this class certification numerosity requirement. It's just basically the class has to be numerous enough. It's typically, I think, has to be like the case law says around 40. T, typicality. The claims or defenses of the representative parties must be typical of the claims or defenses of the class. They must suffer the same type of injury from the same course of conduct. Those are your 4 requirements for certifying a class action. What are the class action types? This is drilled down in the MBE, and they will often, test like how notice requirement, and we'll get into it here. What are the 3 types of class actions here? You've got Rule 20. They come from Rule 23. So it comes from Rule 23B. You've got a Rule 23B1, Rule 23B2, Rule 23B3. I tried to have those like memorized for the bar, but I don't think the B1, B2, B3, like don't freak out if you don't have that, like, you don't memorize that or whatever. Just have in your mind there are these 3 kinds of class actions. For 23B1, this is a class action that you bring where individual lawsuits would create a risk of inconsistent standards for the defendant or impair the ability of other members to protect their interest. For example, a limited fund. So let's talk about this one, the B1, the prejudice class action. This type is used when individual lawsuits would create a logistical nightmare or an inherently unfair result for the parties involved. This is in 2, right? There's that or statement there. You've got 2 kinds here. Inconsistent standards for the defendant. What are examples of this? If a plaintiff sues individually, the defendant could face incompatible court orders. That's what this class action is intended to remedy. The defendant literally wouldn't be able to comply with one judgment without violating another. So our example here is like a city decides to clear a public park of a specific group of vendors. If vendor A sues individually and wins an injunction saying the city must let vendors stay, but vendor B sues individually in a different court and loses a judgment saying the city can evict vendors, the city faces incompatible standards of conduct, right? You've got one court saying you can evict them. You've got another court saying the vendors can stay. You can't have that. So a 23B1A class action resolves that, right? If it's inconsistent standards, they'll join them together and be like, okay, let's put these all together so it's all consistent. Then you've also got the limited fund. This is still 23B1. This is that prejudice class action. This is still, right, you've got that or statement. So you could have incompatible standards for the defendant, inconsistent standards for the defendant, or a limited fund. So what's the example of this? If individual lawsuits would effectively deplete a shared pot of money, leaving later plaintiffs completely empty-handed, it protects these latecomers. This is the limited fund class action. Our example would be a defective product causes a factory explosion. The company only has a $10 million insurance policy, but there are $50 million in total claims for damages from 500 victims. If the first 5 victims sue individually and win $2 million each, the fund is depleted, right? That amount that there is available is getting sucked out, and the other class members are not, these other people that are affected are getting screwed over because there's less and less money. So in that case, if there's a limited fund, then you would bring this prejudice class action, which is B1. Under B1, notice requirements are discretionary. So what happens in these class actions? If the case is certified, which means the judge looks at those 4 factors, right? Can't, commonality, adequacy, numerosity, typicality. If the judge says these are all met, it's a class action. Okay, then what happens? The court's going to order notice, basically. Like, you have to notify everybody because you're going to have this named plaintiff. They're going to be the representative actually bringing the lawsuit, right? And there's going to be all these affected class members that have no idea that their rights are actually tied up in this lawsuit. So that's the notice requirement. Whether the court has to send out, or the plaintiffs, right? They usually order either the plaintiffs or the defendants, I guess, sometimes if they've been naughty or whatever. They have to send out notice to these other people saying, hey, there's this class action and you're a member. So for this 23B1, the notice requirement is discretionary. That means the court may direct notice or may not. Can people opt out? This is the other big thing. If you're what is opting out? In these class actions, the money gets divvied out to all these people, right? And so if you have like a settlement, that's why a settlement requires court approval in a class action. The court looks at it, make sure it's like fair, and reasonable to everybody, because once the claims are released, these unaffected class members, the people that are not the named plaintiff, that are part of the class, their rights are being extinguished, right? They're saying, hey, the defendant's going to pay this money, and then you can't sue them for those claims that are alleged in the class action. So you have to notify those people your rights are being affected, and also do they have the ability to opt out. Opt out is saying, I don't want to be a part of this class. I actually want to sue the defendant individually on my own behalf. I don't want to be lumped in with all these other people. So for 23B1, your opt out, no, class members are bound. They cannot opt out. So there's your 23B1 class action type. Let's look at the second type. This is 23B2. Your 23B2 type is the injunctive or declaratory class action. This type of class action is used when the defendant has treated a whole group of people uniformly, and the remedy sought in a court order is a court order telling the defendant to stop doing something. Okay, so when it applies, the primary relief sought is injunction, right? You're saying, hey, we're all being screwed over by the defendant. We want them to stop what they're doing. I'm not seeking money. I just want them to stop violating the law. Then you would go under this Rule 23B2 class action type. Again, notice is discretionary. The court may or may not direct notice. And can they opt out? No, they cannot opt out. So there's your 23B2. Last one is money damages. That's what all the lawyers sue under. Everybody wants the money, right? So this is what your most common class action is. The 23B3 is when you're seeking money. And this is the one that's going to be tested the most on the bar. So let's talk about it. Let's see here. Okay, the damages class action. This is the most flexible, common, and highly scrutinized class action. You're going to see it on the bar exam, maybe. It is the go-to category. Why? Because you're seeking money. So when individual claims are too small to justify suing on one's own, you're not going to bring a lawsuit for $5, right? But, if one defendant is screwing 1 million people over for $5, those people, they want to sue, right? And say, hey, I've got screwed over $5. Nobody's going to bring a lawsuit for $5. That's crazy. So that's the whole rationale behind this procedural class action. You aggregate all the claims and you say, okay, now it's worth a lot of money because they did it to a lot of people. So when individuals' claims are too small to justify suing on one's own, you aggregate them together. You have this 23B3 damages class action. There's 2 extra hurdles that we want to note here. So because money is on the line and people have a constitutional right to their day in court, a B3 class requires the plaintiff to prove 2 extra elements: predominance and superiority. That's a little in the weeds, but you want to know it, right? I mean, so you've got this cant, commonality, adequacy, numerosity, typicality. For these B3 damages class actions, you have to prove predominance. That's common legal or factual questions outweigh the individual ones. They predominate, so the legal questions to the class predominate over the individual claims. And superiority, a class action is the single best or most efficient way to resolve the dispute. Those are your additions when you're suing for damages class actions. Our example here is a credit card company sneaks an illegal $15 account maintenance fee onto 2 million users' bills. No single person is going to hire a lawyer to sue for $15. It would cost more for the consultation. So, however, a 23B3 class action allows one named representative to sue for $30 million total. Our common question here is, was the fee illegal, and does that predominate over individual questions? How many months did John Doe pay the fee? So on and so on. They'll talk about all these factors and analyze. That's what we're doing here in the bar exam. We're just analyzing everything. You have a framework, right? This is not creative writing. They just want to see, hey, they've got these frameworks for analysis. That's going to be your job. If you're like a clerk or whatever, you're just putting it into, here's the law. Here's everything that we've said in our 400 other court opinions. It's the exact same here, and you apply it on the facts. So that's what we're doing as lawyers. 23B3, let's talk about our key requirements of, we did predominance and superiority. Great. I think that's about it. I think that's pretty much everything. I can't think of anything else, I guess. Just the certification order. It is appealable. I guess that's something that you might want to know. You have to appeal within 14 days. So if the court denies cert, you have 14 days, a pretty tight timeline to appeal that decision. it's a Rule 23F, right? Because all the class action stuff is in Rule 23. You've got an interlocutory appeal here, which means you don't have to wait till a final judgment. You don't have to wait all the way through trial, right? You have a judge. What happens in these class actions is they certify the class action and then it gears up for trial. So you're going to try it on a class action basis. You're actually going to say, hey, the plaintiff is going to show up and say, I suffered these damages. All these other people did too. It's certified. The judge certified it as a class action. It meets all the requirements. And now we're going to find out whether the defendant's guilty or not, right? Well, you don't have to wait all the way for a class action trial and through judgment or summary judgment or whatever. You don't have to wait for a final judgment if on a class certification order. It's immediately appealable. There's this interlocutory appeal that's provided under Rule 23F. You have 14 days to file the appeal. Again, settlement and dismissal is unique in a class action. For settlement, if you're suing in court for individual claims, like I sue my boss for sexual harassment, then if we have a settlement, that doesn't have to be, the amount doesn't have to be disclosed and the court doesn't have to look at it. You just have like a private contract with another person or the corporate entity, right? More likely you're suing the business. If it's on an individual basis and I'm saying, hey, I'm saying this business screwed me over individually, if I reach a settlement with them, they're going to draw up the settlement document. It's just going to be between me and the company, and nobody has to approve it. But in these class actions, if it's a class action and there's a settlement, that's going to be a class action settlement, meaning you're going to release the claims of these non-named plaintiffs and you're going to send out money, right? And say, hey, you can't sue for whatever, here it was invasion of privacy, or it could be like that $15 bank credit. Apple got sued for, data privacy and so on. If it's a class action like that and there's a settlement, the court has to look at the terms of the settlement. They have to look at the actual contract. They have to find that it is fair and reasonable to all the people whose claims are being released, so that it's a safeguard, so that you don't sue, these class action attorneys don't sue and then reach like crappy deals that affect the rights of lots of people for no money, right? Maybe the lawyer is a little unscrupulous. That's what it's intended to protect for. Awesome. I think that's about it. Again, get at me until this upcoming July bar exam. After that, I can't promise anything. I don't know what's going to be going on in my own life, but I'm here to help. And if you get on Patreon, I'll be, obviously anybody paying me money, I'll be more than willing to take recommendations for what you may want lectures on or whatever. So let me know. Happy studying, everybody, and good luck. I know it's getting close. Don't freak out. Just try your best. Don't get too into the weeds. If you're struggling a little bit with some of these like concepts that are way out in the weeds, just try and get all the stuff that is the absolute bread and butter of the bar exam, like duty, breach, causation, damages kind of stuff. Make sure you got all that in your mind, 100%. And, just by looking at all of these actual bar questions, the more bar questions you look at, the more you're going to see patterns of like, what do they typically test? So for instance, here you've got the civil procedure question. There's this standing question here in there for, injury in fact, traceable to the defendant, and redressability. You're going to have those three prongs just kind of ready to go. Those meaty topics are what you really want to have for sure, like your requirements, 1, 2, 3, and list them out. And for class actions, remember CANT, C-A-N-T, commonality, adequacy, numerosity, and typicality. All right, thanks, everybody. Have a good one.